here's what nobody teaches you. Not at school, not at work. The moment you sign, everything after that is already decided.
Majority of our clients that have made a mess or they're in dispute is when they would come to a solicitor to get legal advice.
So many people, they just put their document in ChatGPT or Claude, and they try to be like, we become commercial lawyers ourselves.
These tools are great generally, but they cannot replace lawyers.
So I think many people, they don't even know who a commercial lawyer actually is.
Yeah.
They just know a lawyer who go to court, and that's a common scenario that people understand.
It's not the concept that lawyers are very expensive. If you break that down, it's actually it's a myth.
Welcome back to Big Decisions, the show where we break down the biggest decisions people face in Australia with the experts who handle them every day. Today, one problem, and it might be the most expensive problem in this country: signing things we don't fully understand. A lease, a deal with a cousin, a loan to a family, because here's what nobody teaches you. Not at school, not at work. The moment you sign, everything after that is already decided. And I couldn't have asked for a better person to solve it with. My guest came to Australia from India, built her own law firm from ground up, and became a recognized lawyer in this country. Businesswoman of the Year, Legal Professional of the Year on the Victorian Multicultural Honour Roll. You have seen her on ABC's The Drum. She teaches law at Deakin, and alongside all of it, she co-founded a charity helping women escape violence. Because she decided the law should work for the people it usually forgets. Mannie Kaur Verma, Principal Solicitor at Regal Lawyers. Welcome to Big Decisions.
Thank you, Karan. Thank you for having me.
Thanks for coming on the show. Now, Mannie, let's start with your journey first. Before the awards, coming from India, was law always a plan?
Yeah, well, I came from India quite young. So my family migrated when I was 9-year-old. Growing up, I was quite interested in the legal broader field. A lot of my family comes from the army. My grandfather was in the police, so I was interested in law enforcement to begin with. I did want to join. I wanted to actually join the army initially. My father was quite against that. So then the alternate option really was law. So I think about year 9 is when I decided I'd start studying law when I'd get into university.
Oh, that's very nice. And why your own firm? Like normally, with your kind of CV, I normally see people, they stay in the corporate and they climb that ladder.
Yeah.
So why did you decide to start your own firm?
Yes, I guess I was quite lucky that I found my first job in a law firm quite young. I was still studying law, and then I started working as a paralegal.
Oh, that's really nice.
So I think I was in second year law at the time, and I had the opportunity to study law full time and work full time. Deakin was one of the only universities at the time that would do off campus law. So because I was doing that, I could work full time, and I learned the way law firms work, the way most mid-tier, top-tier firms work. And I realized quite early on that there's not a lot of flexibility for young lawyers. And I had other plans. I wanted to get married. I wanted to have kids, quite early on. And I knew that wouldn't work for me if I worked in a corporate law firm. Quite early in my career, as soon as I became an unrestricted solicitor, I decided to open my own firm.
I think that's really nice because I also work in corporate and I know the pressure.
Yes.
And I've done a law degree back in India as well. And, when you hear about commercial law, especially the one that you practice, you think the Harvey Specter kind of law, and it's you like that part of it. But when you actually do the research, I did it myself and I was like, that's a lot of work, a lot of hours into it. And one thing you have to decide either like which way you want to live your life. And that's very important decision you make.
Yes.
And I think starting your own firm, you get a lot more opportunities as well. You get to meet new people and do so many things.
Yes, and it's also the flexibility, I guess. When you work in a corporate firm, whilst, yes, the work is, there's long hours in terms of work, but there's also the culture aspect. Like to be able to climb that corporate ladder, as you probably are aware, you've got to go out to the Friday night drinks and a colleague's birthday, and there's a lot of expectations of you giving up your evenings. Yeah. And I think if someone wants to balance that with marriage and kids, that can be quite difficult, particularly when you're in early stages of a relationship or early stages when you're kids are quite young. And I think being able to open a firm certainly helped with the flexibility. I could start work late. I could manage kids. I think it's much easier now after COVID. But back when I had my first kid, my daughter, in 2015, I don't think the concept of working from home in a law firm even existed. I remember as a paralegal when I was working at a firm in South Yarra, one of the lawyers there, and she was quite senior, she worked 4 days from the office and 1 day from home. But even that was quite significant. We weren't allowed to tell our clients that she was working from home. We had to say she's in court. Like it would create the stigma that she works from home 1 day, and it just wasn't acceptable.
I think COVID changed everything. It gave that benefit of, now many people I've seen, they work full time from home as well.
Yes.
And this culture is actually growing, and people are more, every place you go, even when you're looking for a new job, one question that comes from everyone is how many days work from home. So that's become a very common thing now.
Yes, I think that's been great for a lot of working mothers.
True. And you just didn't stop at firm because you also co-founded Veera Brave Girl. What did you see in your office that made you start it? Like, what was your major goal or major motivation that made you start this?
Yes. With the firm that I started, sort of to take a step back, my key goal really was to try and cater for the audience that general law firms don't, particularly larger law firms. So for us, majority of our clientele are migrant community. It is Southeast Asian communities. And what I found was there was a lack of understanding about legal rights, particularly for women that were trying to escape domestic violence. They sort of knew the broader concepts, but wouldn't know how to access wouldn't know how to access the legal system, wouldn't know what forms to fill, wouldn't know who to even go to, who to call, what lifeline existed, what resources are out there. So the whole point of the charity really was to try and bridge that gap and try and provide them the ability to access resources. So we didn't necessarily wish to, from my experience, there were already a lot of support system out there. They just didn't know how to access it. So the whole idea was really to educate about what exists, what the different pathways are, what the legal rights are, how to engage in the system, learn the basic terminology. So that was the key idea. It turned out to be quite successful. People were very supportive. So we were very lucky and fortunate. We've had organizations put in pro bono hours to assist with the charity. So we had Infosys that did a lot of the website work for us. They'd helped us develop resources. We had other organizations, even barristers who worked pro bono in building resources. So I think we've been very lucky in that regard that the community put their hand up, helped support and build those resources. And a lot of women have been able to access these resources. Like we've been able to distribute this booklet that has all the legal rights in simple, plain language. What was really eye-opening was some of the terminology we use on a day-to-day basis. We just assume people know what that means.
True.
Like we use a lot of a term that you might have heard, IVO, intervention orders. I was just surprised women wouldn't know what IVO meant, and we just take it for granted because we hear it every single day.
Right.
So it was just sort of breaking that down, because when they go to the police or they go to the court system, people just throw words and they're just so lost. Like they're already dealing with a lot, and you hear all these new words and it's like, what does that even mean? Like, I don't understand. So it was just trying to break it down to a very basic foundational level. It doesn't replace any legal advice. I think people that are trying to navigate that pathway, particularly with financial separation, I would strongly encourage you to get independent legal advice. But I think it's good to have a tool that gives you or supplements that advice. So it gives you the understanding. So when you go and ask the questions, you know what questions to ask. So I think that's why that booklet's been quite helpful.
Oh, that's really nice, because I feel like, as you said, community has been a great help to you. I believe taking the first initial step is the most hard one, and that you did. And I think that's a really great initiative for everyone, because I'm an international student here myself, and I'll say there are so many rights I'm not even aware about. And even when you search about lawyers and everything, one thing, because this country is very expensive, and with lawyers you hear is a lot of fees that gets associated with it. So, but I believe, when I was researching for this podcast itself, so when I was going through resources, there are so many resources that are available, but people are not aware about it. So I think organizations like Veera, they play a really good role in educating people, and that gives them the comfort to actually reach out. They know who to reach out at that time. I think that's a very important thing. And thank you for that. Now let's get into your actual job. So I think many people, they don't even know who a commercial lawyer actually is.
Yes.
They just know a lawyer who go to court, and that's a common scenario that people understand. So
Yes.
what basically a commercial lawyer is, and what's your day-to-day life like?
Yes. I'll answer the second part first in terms
Yeah.
of day-to-day life. I think I've been lucky that I've been able to practice in quite a breadth of areas of law. We run a journalist firm, so we do quite a variety of work. So in terms of commercial law, I guess the key focus really is on contracts or any commercial disputes. I personally enjoy being in court, so we do take on a lot of disputes that end up in court. But it could be, it's just a variety of matters. It could be, you've bought a business and there's been a dispute with your partners, or there could be a dispute between vendor and purchaser. It could range from, if someone's made a promise and then hasn't delivered on that promise, as a result you've suffered some kind of loss. So it could be quite a wide range of matters. So I think each day looks very different. There's certain days that I'd be in court, other days we're just in the office and providing legal advice, or we're typing up documents and spending hours trying to format on Word. So every day looks very different.
Oh, that's really nice. And I think, as you mentioned, it normally revolves around contracts. Now, can you tell me the ratio of clients that come to you before making the mess, and versus the ones who comes after actually signing the actual contract?
Yes, and I guess the backstory or the context to that is majority of our clientele are from migrant communities.
Right.
So I think that it's more of a culture thing. So I would say the proportion, or the ratio would be, the percentage would be quite high for clients that have made a mess or they're in a dispute, is when they would come to a solicitor to get legal advice. Not a lot of clients I think it's just a migrant community mindset, and the way we've been brought up. And like you said earlier, there's this perception that lawyers are too expensive. So I've found that quite strange, is that people will not necessarily seek advice prior to entering into contracts. And majority of the time it's when there's there's a red flag or something's occurred, something's triggered it, and then that's when they would come and seek legal advice, as opposed to saying, well, I've got this great business idea, or I've got this opportunity, let's go get advice. That's not necessarily the first thing in most of our clientele's mind. I don't think that's the first thought that comes to their mind.
Right. And what does the conversation sound like when they come, after that triggered event has happened?
Yeah.
What sort of conversation? Take me to that office room.
Yeah, look, I think it's, and we tell this to our clients all the time, and it is about education in our community. It's not the concept that, lawyers are very expensive. If you break that down, it's actually, it's a myth. And I think, and every law firm is different. Like, there's different types of billing. With us, we've tried to make it more accessible, the legal system more accessible to migrant communities. So we generally will offer fixed fee services. So from day one, when a client does come to us, we will let them know what amount this particular step will cost them, or we'll give them a cost disclosure that's quite transparent about what the investment is in trying to get that legal advice. And if you break that down, like we've had clients where they're purchasing businesses, say, for $900,000. To get legal advice, it might be $2,000, $3,000 maximum. If you consider it in that context, it's much cheaper to get legal advice. Whereas if you were to go to court and there's a dispute that's arisen, just your court filing fee would be $2,000. So it's going to turn out to be much more expensive trying to fix the mess later on than just getting advice day one.
I think it's just like people think these are not very big things, because when they're signing, normally, we sign a lot of things on daily basis. And even when you are signing the contracts, you believe the agent, you believe the person who's bringing you in, that he understands it. But I feel like trust is one thing, but taking your own safety is another thing. So
Yes.
engaging a professional at the right time is very important. That's my personal belief as well.
Yeah.
And what is the one sentence you hear over and over, because you deal with so many clients, and most of the clients, as you said, come after making a mess. So what's a major sentence they say in your room?
Yeah, I guess the biggest thing that we see, or the biggest thing we hear, we didn't document anything. I just trusted. We had this conversation. A lot of time you're having this conversation in very informal settings. We sat at someone's house and came up with this idea and said, let's do it. And we put in all this money, and we just, we knew this person for a long time. There's no issue, like there were no issues. We couldn't obviously they don't really think about it. They don't really anticipate what issues could arise in that setting if you're meeting socially and you've come up with this idea. So I think, most of the time it's like, well, we didn't think there were going to be any issues, and we just trusted the person. We knew them for years, and what could possibly go wrong?
Right. I think I didn't know that is a major term, that comes around, and it becomes one of the most expensive mistake
It does.
they have had.
Yes.
And I think this normally happens because on day-to-day basis, as I mentioned before, we sign many contracts. Like, let's take an example, gym membership. When we sign something there,
Yes.
and phone plan, rental, job offer. So we do sign, we tick a lot of I agree on it, and we do that thing.
Yes.
And we don't know actually what's going to happen, and most of the people, they don't even read it.
No.
So what do you think? How many contracts do people sign on daily basis that they don't even they're not even aware that it's gonna implicate them and later if anything goes wrong?
Yeah, I think it's about trying to make that distinction. So I think the way the society operates right now, we enter into so many contracts that we don't even think about. Like, even just entering into a parking lot, there's the terms and conditions outside, and you grab a ticket and you agree to those terms and conditions. We don't even think about them. It's just so normalized. And like you said, similarly, you join a gym membership, no one's reading those terms and conditions. You just sign at the bottom. You listen, you hear what the agent has to say, the sales rep has to say, and you sort of sign it. And similarly, like if you're buying a phone or you're downloading an app, there's terms and conditions. No one's reading those.
Right.
So that's just the way we've normalized entering contracts. And it does, I think, in the context of that, if you think about the larger aspects, it does make sense why we don't necessarily feel that we need to go to a lawyer every time we sign a contract. I guess the issues really are when these contracts are quite distinct from contracts where you're entering into partnerships, or you're entering into, or there's large sums of investment where, with gym membership, there tend to be a monthly sort of membership. You do have someone, a sales rep, explaining those terms briefly to you. So I guess that's a bit different to when you're trying to set up a new thing and you're just signing on that basis. So there is a bit of a distinction. Also, a lot of these consumer contracts are regulated well within Australian consumer law. So if there were issues, there are ombudsmen, there are other avenues available to you to make complaints. Like you said earlier, a lot of people don't know about these resources and don't know that those avenues exist. But a lot of these consumer law type contracts are regulated, and there would be an ability to make complaints if something were to occur. You're not necessarily out of pocket to litigate it in court. Whereas if it's a civil dispute between two partners, consumer law doesn't tick in. It does, but in the sense that you would have to spend the money to file it in court, and you'd have to spend the money to sue the other person to claim any damages. So it's quite different in terms of what the consequences are if something were to occur.
And are all of these considered as contracts, or because, as I mentioned, we send so many things, and you also mentioned, even reading on the parking is something that we have to take, that also becomes something kind of a contract. But are all these things that we are doing on daily basis are considered contracts?
They are. The terminal or the definition of contract is quite wide, but they would all fall within a contract.
And will all of them, take us to court if anything goes wrong?
Probably not. I mean, I think if it was a parking issue, or when you've parked, well, it depends on how large the issue is. I mean, if you parked in a parking lot and there was some sort of negligence on part of the provider and your car was damaged, you'd end up in court more likely than not. But if it was just, a minor sort of stuff, you might just complain to the ombudsman, or you might complain to the authority, there's a lot of state-based bodies.
Right.
So there's other avenues that are available. So you don't necessarily need to spend money out of your pocket to litigate it in court.
I understand. And one thing I know about contracts is they are, binding are all contracts binding, or because I know there is two different terms, binding and non-binding. So can you just explain a bit more on it?
Yes. I think you speak to any lawyer and we get very frustrated when people talk about, the MOUs, or they talk about heads of terms or non-binding contracts. I think any lawyer would tell you that we don't like those terms. So what's the point of having a contract that's not binding to begin with?
Okay.
I understand that it sort of sets out the terms or sets out what the intention might be, but most lawyers would only encourage you to sign contracts that are legally binding. Otherwise, there's really no value of having a document that's not binding.
Yeah, that's what I've been thinking, because when you say non-binding, what is actually
What's the
point?
exactly?
Yeah, why do people do it? But I still feel like people are still creating those sort of
Yes.
contracts as well when they are, getting into an informal kind of agreements or those kind of things. They just want to set the pace, and
Yes.
they just want to be like, we have something written, even though it's not bounding. One of the party knows it, the other party doesn't know it. I think it's just creating an impact.
Yes,
as
that's
well.
right.
So,
I mean, I
yeah.
think at larger scales it makes sense. Like you'd hear, governments enter into MOUs all the time, but it's sort of more about saying what the intention is and how they want to proceed. That sort of makes sense in that setting. But on a day-to-day base, where you're looking at, buying a shop or buying a business or buying a house, it doesn't make sense. Like I generally would not recommend, and I'd say to clients to not sign. And I think it also is just about lack of understanding. A lot of the times, people are asked to sign heads of agreement from a real estate agent will ask them to do that, and sort of get where they're coming from. A lot of the time, the agent will ask someone to sign a heads of agreement because they want to secure the deal.
Right.
But it doesn't really, like from a legal point of view, if I was actually for the purchaser, I'd be saying, well, no, sign a binding contract. What's the point of signing one? So it just depends on the setting and the context as to whether it's necessary or not.
I understand. And as I mentioned before, many times, can we give an excuse that I didn't read it or understand it? Does the law actually care in that regard?
It's quite a wide. It just depends, and I really had told myself I'm not going to say it depends, but it really does. It depends on the situation.
Oh, okay.
There's different defenses available to different clients, and depending on the case. So yes, there are certain defenses at law that talk about, like, I didn't understand, or I was under the influence of someone, or the circumstances were such. So there are defenses about unconscionable conduct, misleading, deceptive conduct, all that kind of stuff, where it may be a valid defense to say I didn't understand the terms that I was signing, particularly if you talk about cases where the person might not have English, might be a second language, or not have enough understanding or literacy to really comprehend what they have signed, and they've simply signed, and the person that's asked them to sign is quite aware that they're not understanding what they're signing, and has just said, well, you can just sign here, you don't need to understand, you don't need to read. So in circumstances like that, yes, there are defenses available, but for most people where they've done a similar transaction in the past, for example, if we talk about buying a house, we've got a case right now actually in court where someone has signed a contract of sale to buy a house, and they're trying to plead the defense that, we didn't read the contract. We didn't think it was going to be binding, in the sense that we were misled by the real estate agent who said, sign this contract, but I'll flip it. Like, I'll nominate someone else, I'll flip it. You won't be out of pocket. In circumstances like that, it's quite difficult to say, well, I signed a contract, but I didn't understand the terms, but I signed it, particularly whether in the past they've already purchased properties, so they understood the binding nature of it. But in that case, there might be other defenses available against the agent who had said, yes, you're signing a binding contract. So they were quite aware they're signing a binding contract, but they did it under certain representations made by the agent. So there are defenses available in that regard, but for majority of people, I think it's important that you read the contract.
I think it's one thing that I got out of this is basically the intention that is behind it, and I think even court is looking after the intention. What was actual intention?
Yes.
That may be one of the area that they might be looking, if the person actually didn't read it, or they are just saying they didn't read it, because people use law in the other way as well. People try to use law in order to save themselves. So that's another area. And the next question was basically regarding English as a second language. You already answered it. So that's really nice, because there are many people who don't know what English is, but when they come to Australia, they're still signing basic things, because they are like, they won't be allowed to enter at that place. Or let's take an example of a gym. When you have to take a membership, you have to sign everything, and if you don't understand it, that makes even if you don't know the language, that is the only language that the contract is available in, and that's so either you take it or either you leave it. So I think if the defenses are available in that regard, that's really nice, and I think people should understand it. They are not stuck. They just have to go to a right legal professional and they can help you out.
Yes, and I think it comes back to the point that you raised earlier about intention, right?
Yeah.
So contracts are really about both parties having the same intention, but if language plays a role, or the contract is poorly drafted, which we see a lot, but if the contract is poorly drafted, it doesn't really articulate what the actual intention was, then there are avenues to be able to get out of that contract.
And that completely makes sense. And now let's talk about the contracts that we don't actually sign, like a WhatsApp message,
Yes.
verbal communication with someone, or just a handshake. So are those considered as contracts as well, or for a contract to be a contract, it has to be signed?
Yeah, so there are quite a few components. Like I won't bore you with the legal terminology, but as long as it doesn't have to be signed, it doesn't even have to be in writing. As long as all of those components can be, it can be ticked off, can be satisfied that all of those have been met. Yes, you can have a contract that's not necessarily written out on paper and that's not necessarily signed. So text messages can form part of terms of agreement. Emails can be terms of agreement between parties. Even discussions over phone. The only difficulty, the caveat that I'd put to that is that it is on you to prove that in court. So, if it's a phone call and it's not in writing, it's really you standing in the witness box and saying, well, we formed a contract and he said this and I said this. So a lot of that is going to be based on your credibility and how well you are able to remember or recall what the conversation was, how certain the terms were, because that's the difficulty with verbal contracts, because how clear were the terms, how well was it articulated that, for example, we'll buy this car and we'll do this and it's going to be shared and you'll put in X amount of money and I'll put in X amount of money and we'll get a loan where we're both guarantors. How detailed was our conversation? How much can you recall? Because the problem also is from the time that this occurred till the time that it's become a dispute and the legal system the way it currently is, by the time you lodge it in court, your hearing's probably a year away. Well, how much do you remember when you're in that witness box?
Right.
So yes, there's a contract, but is it going to be easy to enforce? Probably not. It's probably best to have it in writing.
I think it's basically just your word against the other person, and
Yes.
Now you have to just be who's going to be more convincing. I think.
Yes,
That's gonna
and not
play the
only
role.
that, and I think a lot of people tend to have this, and probably it's just the TV drama that we watch and have this perception that when you're in cross-examination or you're in court that you'll perform great. Like I've had clients where we've thought they're great. They've been able to give instructions very clearly, and we've sat in conferences prior to a trial and they come across really well. And it's like, oh well, he'll be great in the witness box, and they've got into the witness box and been cross-examined by the opposing counsel who knows what they're doing. And it's not an easy job. It's not easy to stand in that witness box because at the end of the day, when, if it's my client and we ask open questions, we ask you to tell the story, but the opposing counsel is not going to be as generous and as they're going to be quite brutal, and you're
That's
going
their
to
job.
be exactly, and you might have gone into that witness box thinking I'll tell my story, but you may not get the opportunity to do that, and what you say may be manipulated in other ways. So I think people that tend to think that it's I'll be fine in the witness box, it's not an easy task. It's quite difficult, and your body language says a lot. You are judged on that basis, and there's credibility issues, and often in my experience the truth comes out in the witness box. So if you think that you'd be great at telling a particular story that may not necessarily be true, it's not that easy.
I think I've heard the similar thing in TV shows as well, as I mentioned before. Suits.
Yes.
And it's most of these kind of things get settled outside that room, just because they don't want to be in that thing explaining everything. And the same thing, when you get the date of the law, how much you remember, that is another area. So
yes,
that's
and
good to know,
majority matters. You're right. Do settle out of court,
Yeah.
and there's a number of reasons. One is you don't want to be in a witness box, which
True.
makes sense. Other, cost implications. Like even if you've got a solid case, we've had matters where we've got one right now. It's a personal injury matter. I think our client's got a very good defense to that matter, but it's just, how much money do you want to spend on this? And it's the stress and the cost associated. And there's a number of reasons why we would encourage clients to settle it.
I think it's just not about justice. It's about all other factors that people have to
Yes.
look on when they're making this decision, because it's not a small one,
No.
and it can become a big one even if they didn't think it that way. So I
Yes.
think that is a professional advice that people actually need from good lawyers. I think that's really nice. And when we're talking about contracts, as we mentioned, a lot type of contracts. What type of contracts do we normally need to see a commercial lawyer for, and which ones they can do it themselves? They're like, it's okay.
Yeah, I think any lawyer would say most contracts.
Yeah.
But if you're getting into any sort of commercial investment, any partnerships, you're purchasing a business, you're investing in a business, you're buying shares, selling shares, you should get legal advice.
Right. Completely makes sense. And just another question is basically, with the advent of AI, now so many people, they just put their document in ChatGPT or Claude, and they try to be like, we become commercial lawyers ourselves.
Yes.
And what is your point of view on that? Like, is it beneficial to, get that advice from AI instead actually paying money to a commercial lawyer to actually review it? Because I think that's a question that is coming in everyone's mind these days.
Yeah, no, I think those tools are great generally, but they cannot replace lawyers. And we've seen that a lot lately in the last few months, I'd say. We would book clients in for initial consultation, and we're seeing a lot of people sending through these briefs to lawyer, and it's just come from ChatGPT or Claude or some sort of AI platform, and it's just it just has a length of questions, and then I've reviewed those documents and I've thought, what are these questions that they're asking? And then the clients come in and their dispute has nothing to do with the questions, and you can just tell that they're quite apart in terms of thinking and what the intention of the venture might be, or where they want to get to, what their goals are. So I think the difficulty with AI tools is people don't know how to use them necessarily.
True.
They're not able to input the right questions. I think the tools are great, but it's just how you utilize them. And then, the tools are also not necessarily going to ask you the right questions back, not going to ask you what your intentions are, what are your end goals. And so I don't think that they replace legal advice. I think they're great to supplement that. And I think it'd be great to have a basic understanding of the landscape you're working with, but then go to a solicitor and actually get advice about what are the potential disputes that could arise? What are the particular documents? A lot of the time people will just plug things into AI tools, and they've got results that are based in UK or US, and you're dealing in a Victorian landscape with different legislation. So it's just about learning how to use the tools and using them for that purpose only.
I think that's a good thing you mentioned, because while working, even we use those tools to research the tax laws and those kind of things. But many times I came across because I knew that thing, but I still put into AI to check it, like if everything is okay, and they give entirely a different thing, because based on their understanding or based on my input, what I've given, the information is little bit lacking, or they are taking, because first thing is, no one knows. They know your country, they know your state law, and those kind of things. So you have to be very precise in the type of input you're giving it. And I feel like instead of replacing it with a lawyer advice, people should actually take the lawyer advice, and then they can understand that advice in a better way through those platforms, so that they also know why the lawyer is saying those things. And because no lawyer has the time to explain everything in a small meeting, so I think they can utilize them in a nice way and help themselves in that particular regard. And now let's talk about the contracts. When we are talking particularly about contracts, can anyone put any sort of terms in that? Does the law give them that authority to do it? Like, there are many, if I say I want this thing to be done this way, it's my business. Can I do it that way?
Yes and no. So, I mean, the concept of a contract generally is just, four square, your four corners. So think about like a square, that's your document. And then within that, whatever parties have agreed, that's necessarily, that could necessarily be what the agreement is. The problem only with that is it's just, one, we talk about intention and meeting of that intention. Both parties are clear on what they want to achieve. But there are other concepts, and there has been recent legislation about unfair terms. So you can't include unfair terms, even though both parties may have agreed to that. If it is considered unfair term, there is an ability to be able to not enforce that particular term, and say that not necessarily the entire contract is void, but at least that term is void. There are circumstances where the terms might be so essential that the entire contract becomes unenforceable. There's also this concept where we talk about this quite regularly with clients, because there's this idea that, this particular thing I want to do is not necessarily legal, like it might be illegal. But if I put it in a contract and both of us sign it, then it's fine. And I just think, no, it's not. So just to give you an example, just say if I did an employment contract with an employee and I said, well, I'm going to pay you $18 an hour, and the threshold is say 31 under a particular award. So just because that employee has signed a contract and agreed to be paid less than what the rate might be, that doesn't make it okay. So I'm still breaching the Fair Work legislation. So there are still liabilities and penalties that I would be liable for. So you can't make something legal by putting it in a contract.
Right. And will that make that particular particular side void, or will that make the whole contract
It depends on the term and how significant that term is in the contract. If there are essential terms, then the entire contract could be unenforceable. So you have to be careful that, what's the point of having a contract if it's loaded with terms that are unfair or illegal, then that contract has no value.
So it's not just like you can put whatever you like based on your feasibility. So you have to look at what laws are there in place, and you have to make sure your contract aligns with that.
Yes.
I think that's good to know as well, because many people will be like, many people in small business specifically, they are just like, we want our job to be done this way. So we'll, put our employees, we'll put those things in the contracts, which are not enforceable.
Yes.
But I think even if they put it, even if the contract is not valid, I think what's happening is employees are thinking that it is valid, and it might, something's wrong might happen if they breach it.
Yes.
So I think it's important for them to understand it. Like if they feel anything is wrong, anything is more than that anyone would accept you to do in this job, they should actually, consult a legal professional, or they should, go to the resources, free legal aids or those kind of resources as well, to just have a brief check on it, like if it is okay or not.
Yes, that's right. I think there's so much legislation now to try and prevent exploitation in that regard, particularly in the employment space. And there are quite strict liabilities in terms of sham contracting, where, you on the paper it looks like you've hired a subcontractor, but in fact you're treating them like an employee, and you're doing it, you're making it look like a contract because you don't want to pay super, you don't want to pay annual leave and leave entitlements, you don't want to, but you want that they wear your uniform, and you want them to work the 9 to 5 hours, and you want everything that pretty much an employee would be doing. You want them to do that, but you don't want to pay entitlements, so you call them a contractor. So in that space, there's quite a lot. The legislation is quite extensive in that regard. And there's penalties. There's civil penalties as well. So it's not just it's not that you've just got to pay back the employee. There are very significant penalties for the employers if they're an organization. It's, it can be hundreds and thousands of dollars. Like, it's quite significant in that regard.
Can you explain a bit more on it? Because it caught my interest when you talked about the sham contracting, because I believe right now so many students, so many people, they are being paid on ABN than an actual PAYG employee they're supposed to be. They are doing all the jobs because they feel it's not a thing.
Yes.
And like, if you can just give me an example so that people can understand what exactly we are talking about, and what can be done in that regard, like what rights do they have?
Yes, I think it's very specific to the industry, and there are certain industries that are more prone to seeing contractor arrangements, and so it's difficult. It's difficult to say broadly how it would apply in a particular setting, because the awards are different, the legislation is different. But to give you an example, for real estate agents, we see a lot of sham contracting happening in the real estate agency space. So I can't recall legislation from the top of my head or what the particular sections are, but there are quite comprehensive sections about this, where we were seeing a lot of younger agents who've just become qualified, and the employers will keep them on a subcontracting arrangement or an arrangement where they only earn certain commission. That's not allowed. And I think a lot of people are not aware of this who are running these real estate agencies. There are quite a few steps detailed in the legislation that you have to satisfy. There's a whole criteria, which includes that you must have been an agent for a certain period of time. From memory, I think it's 2 years. But there's a criteria about the length of employment in that space. There's a criteria about what you should have earned in the past. So if, for example, you didn't meet that threshold, then you can't be kept on a commission-only basis. Because what we were seeing is a lot of young people, international students or people that have just come out of uni, real estate agencies will employ them. They're not paying them any salary, so they're working, say, 6 months. They're cutting one deal. So they're getting whatever, say, 30% of commission, whatever the commission the agency is entitled to, they're getting 30% of that. So in 6 months, they're earning quite insignificant amount of money, and it's quite nominal. It's just unfair, but the employer requires them to be in the office 9 to 5, to be making calls, cold calls, letterboxing, all these sort of requirements that they've got to do to try and find business. But they're only able to, cut maybe 1 or 2 deals. They're not making any money, but being exploited really by the real estate agency. So there is legislation about that, and that would be considered sham contracting because they need to be on an employment contract. They should be paid on an hourly basis, not on a commission-only basis. To be qualified for a commission-only basis, they've got to meet all that criteria, which requires experience. So it can't be you just got your license and out you go and you're earning commission only. That's not allowed, which I think a lot of people are not aware of. And just because a contract says it's a contractor agreement does not mean it is. That is called sham contracting. You know very well that they can't be a contractor, and you've put them as a contractor. There's significant penalties and even personal penalties against the directors of the company that's running this.
And because I feel like there'll be many people who lie in this category and they don't even know about it. And what do you think, what should be the next step? Once they see it and they're like, we lie in that category, what should be the next step?
Yeah, get legal advice. Get legal advice early. You'd probably have a claim.
I think that's good to know. And now let's start with the main topic of today. That is, buying a small business.
Yes.
And because there's so many formalities when you start a small business, and it's one of the biggest dream people have. And I think doing it the right way should be the first thing people should, instead of just worrying about paying additional $1,500, $2,000. I think if they are spending so much on their business, they should not consider these costs as a nominal cost. And now let's talk about. I'll give you a scenario today, and in which I'll so that people understand in a better way. So let's say I'm buying a cafe for 200,000. And with my cousin, who's a barista, I'm a working professional. I have the money, and he'll run the cafe while I keep my day job. So we found the cafe. There's a lease on it, and the agent is after me to sign the papers. So my first question is, where do I start?
Yes. I think that's a great scenario. It's a very common scenario. I would say the minute you've decided to buy a cafe or you're interested in that space, get legal advice. The major step would really be when you've got the draft contracts. The vendor's lawyers would generally provide that to you, or the agent would provide that to you, and to take that contract to a lawyer before you've signed it, and try and get advice on the different terms. I think, like you said in this scenario, it's you and your cousin that are buying it together. It's best that you both go and get legal advice. It probably is most ideal for you to get separate independent legal advice at some point, to understand what disputes could arise between the two of you. But just say if it was like a joint venture and there was an entity that was going to be the purchasing entity, then it would be best that you both go together when that contract is being explained, and you have a lawyer go through the terms and you understand what you're signing up for. In terms of buying a cafe, there's a variety of ways that could be done. It could be you're buying the actual business in terms of so that That's to say that you're buying the business name, so you're buying the goodwill as well as the assets, or it could be that you're just buying the chattels only and you're not buying the business name. You're going to have a new business name. So it's understanding what exactly it is that you're purchasing, and that's what a lawyer could explain to you. Understanding what terms you're signing up to. There's general terms in a contract. There's special conditions in a contract. What do they all mean? When is settlement going to occur? What are your finance obligations? Do you want to buy subject to finance or without or you're confident you've got the finance ready to go and you're ready to sign an unconditional contract? So understanding all of that, how many employees are there? What are their entitlements, and will you be keeping those employees or will you be terminating them? What occurs in that scenario? So I think as soon as you have a draft contract, you should be taking it to solicitor, having them walk through the contract. Generally, the way we work and most law firms would work is you provide it to them, they'd make some sort of appointment and then provide you advice. And it's up to you. You want verbal advice, written advice, whatever way that you'd like to sort of proceed in that regard.
Good to know. One thing I feel like when you're starting a business, people don't normally consult lawyers.
Yes.
They go to their accountants directly. So what do you think when as part of the due diligence, what do you think is the right, which all professionals should be engaged in this process? And what is your role in it, and what is an accountant's role in it?
Yes, I think both play a very important role, but it is a very different role, and it's about understanding that.
Yeah.
And I think most good accountants would say, well, this is the scope of my work, but you should consult a solicitor who would give you advice on the actual legal terms. And it's just about understanding where each sits and I think most good professionals would give that advice to the client and say that my role cannot replace the role of a lawyer. Similarly, with the lawyer would be saying, well, our role doesn't replace the role of an accountant, who would give you advice about tax implications, and depending on the structure you choose, setting up the company constitution, and allocating any shares, and giving advice about setting up any trust companies that might be required, or who the beneficial owners.
And that is a commercial lawyer role, or
no, that's accountant's role.
Yeah,
so accountant would really be giving you that sort of advice, whereas the lawyer would really be giving you advice on the terms that are in the contract and what you're signing up to.
Right. I think that makes sense. So it's just, if you want to, like everything else in terms of compliance part, you go to an accountant. But in terms of actually signing the contracts and talking about those legal technicalities, what can happen, what can go wrong later in order to get the safeguard, I think commercial lawyer comes in that place, right?
Yes, that's right. I mean, there are, just not to confuse people, but there are taxation lawyers that provide advice in that regard, but it's a different scenario that we're talking in that regard. You wouldn't really be going to a commercial lawyer to get taxation law advice.
And another thing I hear is, because when there is such kind of exchange, conveyancers normally come as well. Now, what is the difference between a conveyancer and a commercial lawyer in that way?
Yeah, very different, and again, depends on who you go to. There's a lot of conveyancers that would say, well, we practice law back in India or whichever country they migrated from, and so we've got enough legal understanding and we'll help you with this. That's not right. The conveyancer's role is very limited to conveyancing of residential property. That their role doesn't include providing advice on commercial contracts. So I think it's very important to understand who you're dealing with and what their expertise is. Conveyancers, just to sort of give you an idea, to become a conveyancer, you're just doing a sort of a course. You've not studied law. You don't understand. You haven't been to court. You haven't been to law school. You don't have that knowledge or the expertise to be able to provide legal advice. Also, your insurances are different. So if we were to provide legal advice and it turned out to be like we've acted negligently, or there's been some sort of professional misconduct or unsatisfactory conduct, then there's different avenues available to the client if they've spoken to a lawyer, as opposed to a conveyancer who doesn't necessarily have those insurances in place.
The reason I asked this question was because yesterday I was sitting with someone, and he's buying a shop for himself, and he mentioned, I asked him the same thing, did you get the contract reviewed? Because I was researching about it, and I was like, that's very important. So he was talking about it, so I said, let's mention it. And he was like, my conveyancer actually had actually read the things, and I told him. Then I was a little amazed, because I knew one thing, because conveyancers, they, like many conveyancers, they don't have a law degree. They are actually just conveyancers by doing a short course. So I don't know like what legal professional he used, but when he used the term conveyancer, I was a little amazed, and you clarified that thing. So whenever you're dealing in such things, it's better to consult a commercial lawyer rather than just a conveyancer, because they might not have the actual idea about what may go wrong. And in case of dispute, I think it's a better way to understand this way. Who will you go when a dispute will arise?
Exactly.
So I think they will have a better understanding what to do correct, so that the dispute never arises.
Yes, and I think what people don't tend to, and if you look at terms of investment, a lot of conveyancers are charging you similar. Even if you take a step back and look into residential property and where a conveyancer's role is, a lot of conveyancers are charging the same amount as what a property lawyer doing conveyancing.
Right.
So in terms of investment, it's not a lot different. If you just go to a solicitor, a property lawyer who practices in conveyancing, you're better off because which a lot of people don't think about, but your terminology in terms of when you're seeking an extension for finance, or something goes wrong and you're trying to get out of the contract and you're trying to terminate the contract, that terminology that's used at that point in time is so critical in terms of if a dispute were to arise later on, what language was used when you were terminating, and what legal rights might be available as a result of what that termination letter looks like. And a lot of times when these matters end up in court, we're really trying to interpret the language used by that lawyer or that conveyancer. So you might lose out on a significant claim that you have just because the conveyancer didn't have the language, the vocabulary, or the legal understanding, and have just written something that is not going to work in your favor later on. So it's really trying to, like you said, it's about trying to understand what happens if a dispute were to arise. And a lot of times when disputes do arise in property transactions, conveyancers will simply say, go to a lawyer. In that regard, you will be paying more money because then you've got to brief a solicitor, tell them from day one what has occurred, provide them the entire the entire conversation between you and your conveyancer and the other party. So you're spending more money because the lawyer's going to charge you to read all that material.
Completely.
And then, get on board with trying to fix, maybe if someone sent an email and say, well, no, my client actually meant this, and trying to fix that up.
Right.
So you're actually more out of pocket later on.
Completely makes sense.
It is, if you look at where claims generally happen, majority of claims are relating to conveyancing.
Oh, okay.
A lot. I think there was recently a survey done by the LPLC, which is the Legal Professional LPLC. I can't remember what it's called. Legal Professional Liability Commission. Yeah. But they do a lot of the claims against lawyers, and 70% tend to be conveyancing related. So it is it's a very high risk area. It's low investment because you don't pay a lot to conveyancers or property solicitors to do conveyancing. But very high risk.
I think that's the sole reason, as you said, it's a low investment with conveyancers. People just feel like rather than spending more money on a separate legal advice, because they do it daily, the trust factor comes again. And I think, I believe when you're doing business or when you're doing anything commercially, trust should be a little bit part of it, but more should be your understanding of things. And if you are not confident enough to do it, consult a professional, and I think that makes your life very easy in future as well. If you don't want any disputes in life, it's better to pay that small fees up front if you want to avoid that hefty fees later.
Yes, and also I think I don't have any experience in terms of counseling or that area, but what I do find when we work with clients with disputes, it's not necessarily like a lot of people feel hurt and think this person's broken my trust, I trusted this would occur, but a lot of disputes are not related to trust. I find it's actually just different perception. Like day one, their understanding of the transaction was very different to yours, and because you didn't document it and write it out, and you didn't really ask the right questions, you've operated from very different mindsets from day one. So it's not that person went out to necessarily break your trust, and that you might have been great friends from day one, and they may still value that relationship, but it's just that you started from a very different point and they started from a very different point, and there was no discussion to really work through the terms and make sure that, and that's why contracts are important to get to that mutual intention that you both on the same page. And I think when the trust is involved, or there's already a pre-existing relationship between the parties, you don't ask the right questions because you're just you're working from that lens of my friendship, we'll work it out later and that kind of thing. And it's in a commercial setting that doesn't necessarily work.
And I think in our culture specifically, I believe asking someone to sign a contract, let's say if in my scenario itself, I said doing it with a cousin. So if I tell him I'm going to do a contract, it's a bit disrespectful that's what we feel at starting. And the other person might be like, you don't trust me that well.
Yes.
And what is your, experience in this regard? People who just, instead of doing that hard talk in starting, like you might have dealt with so many family disputes that arise in such regards. What is your viewpoint in this? And what do you want to tell them? Like, what is the best way to talk to that person, let's say my cousin, so that I convince him, let's do a contract, and it's not something I'm not trusting him. It's just to make things easy in future.
Yes, I think it's important to have those difficult conversations early on, because I understand that it from that kind of setting and that kind of relation, it can, just because of the culture that we've been brought up in, we can find that it is disrespectful to ask someone to sign a legal contract. But I think it's really important to be able to break away from that mindset and to do it early if you're going to get into a commercial relationship, because later on, if there was a dispute and you ended up in court, that's going to hamper your relationship far more than having that early difficult conversation. And it's also about trying to work out that you're all both on the same page. If you think it's important to have it documented, which I think you should think that, then I think it's important that you relay that to the other party. And if they're not comfortable, I think that's your sign to not go ahead with the contract and not go ahead with that commercial relationship. Because if you can't have that difficult conversation early on, then imagine, later on we're talking about firing employees, you're talking about salaries to either party, and you're having more difficult decisions to make. If you're not able to work through those, then your loss is going to be far more significant later on than what it is early days.
Completely makes sense. And I feel like if you can't make that hard conversation, let the lawyer do it. You just have to get the person to the lawyer, and they can tell them, because it's your everyday job. You know how to tell people and what is a peaceful way to tell it, so that no parties get offended in the relationship side and nothing gets affected. So I think best way is to just reach out to the lawyer and they can help you in that.
Yes, that's right. And then I guess the second step, which is always difficult, is to say, well, you should get your independent advice, and each party should go to separate lawyers at one point and get independent advice, because your interest is going to be different to that person's interest, particularly in the scenario where you were saying, you're investing money, and the other party's working in the business. We see a lot of disputes happen later on where it's like, well, I give it my soul and I worked 9 to 5, and why does he get 50% share, whereas I worked in the business and he didn't? And and there might be situations where the person who's just a passive investor and not working doesn't understand how it works and doesn't understand why he may be firing people, or why there might be a larger turnaround of employees. And because they're not there, they're not necessarily privy to the operation aspect, and trying to really. And then there's times where you're a passive investor, and that's how the position started, and at some point you want to play a role in the operations, and you're trying to dictate how much cake, or what the order should look like, how many cakes they should be ordering, and the person's thinking, well, I was going to handle operations. Where's that coming from? So I think it's really important to have all of that documented. What is your role? What's my role? And so we're not overlapping, and there aren't disputes arising out of not being able to understand where you sit and where that person sits.
I think this thing also gives another advantage, because normally when you start a business, you don't if you're not doing it formally, you're doing it with a family. You don't share your responsibilities that way. You're just like, whatever comes on, we'll take it. But I feel like when you are in that, documentation process, like making a contract, at that time, the questions that are going to come from a lawyer, that will help you shape your business in a better way as well, so that everyone knows whose duty is what. And I think that will make a better business overall.
Yes, for sure. And also because lawyers have already seen the dispute end of it.
True.
So they already know that from experience what kind of disputes arise, and you might not have thought about those types of disputes because you knew into this. So I think it helps in getting that advice, because we're thinking from, this will end up in court if this happens. And I think a lot of times you see clients and you're like, oh, I don't know about this particular transaction. I don't know this about what they're thinking, and I'm not really sure that that's going to work out the way that they've visioned it.
Right. Completely makes sense. Now, as we are talking about it, what about the advice cost? Like, how much does it take, how much a commercial lawyer charges when people come in the starting?
Generally, you'd go to a lawyer, and probably in the first consultation, they'll provide you a cost estimate. So we're legally bound to provide cost disclosures. Difficult to predict exactly what it would cost depending on the business, depending on the types of contracts you're entering into, but it's not as significant as what people think. It's just thinking about it like an investment into the business and its initial investment. We've seen, clients who are purchasing businesses for say 900,000 and are reluctant to spend 2-3,000 to get that initial advice. So it's just about trying to work out. I think it's just the mindset and not thinking that that's a negative cost. It's a positive cost. It's the cost that you spend to prevent disputes later on, because that dispute later on will cost you far more.
Yeah, what does skipping it cost then?
Sorry?
What does skipping this advice
Oh,
cost?
a lot. Well, look, majority of the time, no dispute happens and you're fine. And I think that's where the mindset is created. I've bought businesses before, nothing's happened, and not having a lawyer hasn't costed me anything.
Yeah.
But just because that worked out doesn't mean this will work out. So if it doesn't work out and you end up in court, the costs are quite significant. Difficult to say between different courts, but anything that ends up in, say, magistrates court, you'll spend 30,000-40,000. County court far more than that. And if you end up in a more complicated dispute, it's difficult to predict how long the matter will go. Difficult to know what the defences available are. Easily out of pocket 80,000-90,000.
Okay, that's a big amount. I think spending 2-3K upfront is better than that.
Oh, for sure.
Yeah. So now let's go to the next step. That is the documents. So during the consultation, we know what's going to happen. We discussed about the first due diligence. Now, what documents will you require from me?
Yeah, so generally the solicitor would give you a list of documents they require, but probably a draft. So depending on which party you're acting for, the vendor or the purchaser, but probably the draft contract if you're acting for the purchaser. If it's the vendor, then they'll give you a checklist, and then they'll provide you a list of questions that you need to answer in order for them to prepare the contract. If the solicitor is only reviewing, then they'll ask you a list of questions, and that might be done in a Zoom meeting or in-person appointments. They'll tell you to set aside an hour or two to answer all those questions, so then they can review the contract in context of what your goals are.
Okay, and in terms of the major documents, that is the contract of sale, and if there's a lease, the lease document.
Yes.
Now, let's talk about the contract of sale first. What are the key clauses people should look at?
Yeah, so generally there's the clauses are divided into general conditions and special conditions.
Right.
Always look at the special conditions because some of them will delete the general conditions. They will replace the general conditions. What are they? Most people are across general conditions, or the lawyers are very well across general conditions. To sort of give you the background context, general conditions are in your standard LIV contracts. They're there to protect your rights as a purchaser. They're sort of a balancing field. They will protect both rights as a purchaser and a vendor. Special conditions are generally inserted by the vendor's lawyer, so you know who they're likely to favour.
Right.
So best to always look at those. If you're purchasing a business, to look at the asset list, know exactly what you're purchasing. You don't want to walk into a restaurant and just say, oh, well, it's missing all the tables and chairs and it wasn't in your contract. Furniture wasn't there. So, understanding what you're buying, what you're being provided with. Any other hire contracts, is there a fridge that's on lease? What are the terms for that fridge? Or what are the terms on that agreement? Understanding employees, what are the employee entitlements? How many employees does the business have? Will they be transferring or will they be terminated? So a lawyer would generally walk you through all of the relevant aspects of that contract.
Right. And what about the lease agreement?
Yeah, so similarly, the lawyer would generally walk you through the lease. A lot of the times when you're purchasing a business, the lease is being transferred. So it's similar sort of terms to what the vendor had. So, understanding what the term of the lease is. You can't just walk out 6 months if the business doesn't work. There's obligations to pay rent, obligations to pay outgoings. There may be make good clauses. If you walk out, you've got to bring the premises back to the shell, which means that you've got to get rid of the fit out and paint, and what are your obligations there monetary wise to think about. If you are walking out and you can't run the business, and in the worst case scenario you're not able to sell and you don't want to run it anymore, what occurs then? What are your out-of-pocket costs?
So as you mentioned about lease, the fit out cost you mentioned, because I believe when I'm buying a business and let's say I'm buying an existing business, there's a fit out inside. I believe when I'm paying for the business, I'm paying for the fit out as well. That's my personal asset. But like at end of the day, like you mean to say when I'm finishing my business, when I'm transferring the lease or going to another place, that fit out, I have to remove it on my cost, or
It'll depend on each contract and who owns the fit out. If the landlord has the fit out, then it'd be different. But if the vendor had put in the fit out, then you may have purchased that in your contract, and therefore the fit out is yours. But the lease might have a requirement that if you were to terminate the lease, then you would have to remove the fit out. That is your fit out that you purchased from the vendor. In that case, you've got to remove the fit out and bring back the position and the premise in the same state it was when the lease was originally signed. So that's the make good clauses, and they can be quite expensive depending on different types of businesses, and they can cost you a lot of money. So if the fit out, and again, depends on the type of business, but if the business, say, had large freezers or had large equipment, like we're dealing with a matter where it's a pizza shop and you've got quite an extensive fit out, but the landlord requires you to make good, which means you've got to remove all of that. So it's a lot of cost in getting it removed, a lot of cost in repainting and bringing it back to the shell position that it initially was in. So it's to think about those matters when you're getting into the business. Just because you're buying in, it's not easy necessarily to leave and exit. What's the exit plan?
Like if someone spent 150K on fit out, so one thing is if that's not on the contract, that's like even if it is on for the landlord or mine, I consider it as mine because that's a normal standard person will do. If I'm buying the business, I'm buying everything. But one thing to consider here is basically the cost to take it out, because every owner of the place, they're gonna be like, this I have to give it to other person or whatever it is, and people don't consider that cost in their mind in starting, and that I think that affects some very small businesses a lot, and because it's going to be a considerable amount.
It is.
Disposing things, especially in this country, is a big amount. I recently vacated a house and I paid like $1,500 for rubbish clearance.
Yes.
And that was one of the biggest expense. I feel like I've back in the country, people pay you for it.
Yes, that's right.
And here you have to pay them for clearing it. So I think these are few things that people who come from a different country, they are not aware about.
That's right.
And it's very important for them to know these things as well. They have to consider the cost that they may have to pay in case the business fails, and that should be part of the business plan itself.
That's correct. And you're right about that. The disposal cost is quite expensive. The labor cost to dispose is quite expensive. And the fit out that you might have purchased for $150,000, you may end up paying $30,000-$40,000 to have it removed. Because by the time, to think about it, like things like freezers, you fit it out, but you can't just remove a freezer. It has to be dismantled, and the carpet has to be fixed, or whatever the so ground flooring might be. So there's quite a
and even the dispute goes on later as well.
Yes.
Many people are like, the landlord's like, this is not right. I recently had a similar dispute with my personal residential property as well. The landlord started picking so many things, and I decided I'm not gonna just be like sitting there and he's deduct anything of my bond. So I went to VCAT and we got the bond that way.
Yes.
But I think it's always either, if you don't know the resources, consult someone. Otherwise, there are so many resources online. You just need the time to actually find those resources and get that legal advice. Because I believe, especially this country, like since the time I'm here, people are friendly. People want the authorities want to give you the justice that is required.
Yes.
And you just need to find the right pathway.
Yes, that's right. Particularly for renters, I think there's so much available in Victoria.
True.
There's a lot of most of our legislation tends to favour renters, and there are a lot of resources available. There are certain firms that are set up just to help renters.
True.
And there are certainly pathways available.
I think that's good to know. So I think we need more organizations like Veera as well, that help people just at least giving the pathway.
Yes.
So that they know, like there are so many areas. You're covering domestic violence in that organization, but I feel there are so many areas that are still pending to be covered.
Yes.
That people don't know the right specifically.
Yes. Just to be clear, I have stepped down from VIA even though I did
Okay.
form it, but I stepped down last year. I've started doing other things, and I think it's important to be able to know when to exit and know when to where you want to go. But the organisation itself, whilst I'm no longer part of it, it is doing great work, and I think it's got now it's got the ability to run without the co-founder.
I think that's still you take the initiative. It's running now,
Yes.
and the facility, the benefits are there. So
Yes.
all credits to you in
Thank
starting,
you.
I'll say. So yeah, now let's get back to the topic again. So let's say we signed everything, the business started running, and now it just doesn't work. So what happens in that case? We have signed the contracts, and let's say the lease was for 5 years, and what? And after 1 year, we started facing losses, and we don't want to continue it. What are the options? At
I
that
think
time?
to get legal advice early, to try and cut your losses, and then to engage a solicitor who can maybe negotiate with the landlord's solicitor or their representative, to try and work out a surrender arrangement if you can. There are options available. It's not necessarily the dispute pathway. You don't necessarily have to terminate and walk out. There may be ability to try and surrender, explain your financial situation. And most landlords are not out there to get you. They would like to be able to, they just want someone to pay rent.
Yeah.
And if they can cut their loss and come up with some sort of arrangement that works for you, and they can put in a new tenant, then both parties will generally, between solicitors, will take on a reasonable pathway, and will try and get to an arrangement where it's a compromise for both ends. You may end up spending some money paying a surrender fee, but you're able to walk away without something hanging over your head. It's not a dispute. It's not ending up in court. It's not months and months of stress, and also resources, your money that you're spending in legal fees and in court fees and so forth. So you can avoid all of that by getting advice early and trying to arrange some sort of arrangement that could help you walk away with releases, so there's no threat that tomorrow the landlord's going to sue you or you're going to sue the landlord, and you're able to come to some sort of mutual arrangement such as a deed of surrender.
That's good to know as well. So it's not like if the business is losing, we have the lease on our head, because I think specifically with leases, when you deal with commercial leases, it's a lot.
It is.
And it's a lot of liabilities people have to pay at the end if anything goes wrong, because it's signed for a long period, and
Yes.
if you have not consulted a lawyer before, you don't know if any such clauses are there that may affect your exit at
Yes.
that time. And I think it's very important, as you mentioned, to check everything up and take the advice earlier. If you feel like your business is facing losses, just get the advice, even if you are willing to wind up in next 5-6 months. I believe it's going to take that time to implement that advice as well. So
Yes.
yeah,
Yes, for sure.
I think that's nice. And now there'll be some other liabilities that I have to pay as well. What about them? Like, what are the options?
Yeah, so I think with most of your liabilities, it's best to stay on top of it. You don't really want to affect your credit rating.
Yeah.
But whatever your supply agreements you've got, you've sort those agreements out. People often forget about personal guarantees just because your company shut, the business has failed. If you're a personal guarantor to any of those agreements, then there's liability for you. The other party to the agreement can enforce their rights against you personally. You don't want to be putting your personal assets on the line, so it's best that you sort those out. If there's, again, ways to negotiate and try and terminate those agreements with mutual releases, that's probably the best way to go about it. You don't want to be in a position where you think, because my company's done, I don't need to pay anymore. That's not necessarily the case. So, for example, you've taken out a business loan, and just because your business has failed doesn't mean you don't have to return that loan. You have to pay that loan. It's better to be initiate those processes early, and to try and come to some sort of prepayment plan or some sort of plan or some sort of installments or whatever the case might be, as opposed to letting that go into default and letting debt collectors get involved and your credit rating's affected and you're not able to refinance, and things just get worse later on. So I think what we do see a lot, and again, it's a mindset thing, people tend to kick the can down the road, and the longer you kick it down the road, the worse it becomes. It's better to be on top of it early on and try and get advice to try and resolve these matters before they become difficult to resolve.
I think that's good because I feel many people, when they form a company, they are under that thing that company is gonna save me. It's a separate entity. Now people know it, and they form a company specifically for that reason. One of the major reason of
Yes.
opening a company is that, and many people feel whatever the liabilities are, it goes with the company. Whatever options are there with the company, but as you mentioned, there are personal guarantees, and they can come onto your own assets later
Yes.
if you don't take the right steps
That's
at,
right.
at that time. And now let's go to the flip side. If someone owes me money at that time when I'm closing the business, and I think that's one of the reasons people normally close business, because people are not paying off their money. So what are the real steps, and what do you think, how long does it take, and what it cost, and is it really worth chasing?
Yeah, so I think it's important to understand what those agreements look like. So if someone's owing you money, what are your rights under your agreement, and try and enforce that early on again. And again, not leaving it to too late, because the person that owes you money might become bankrupt, or if it's a company,
Yeah.
might be closed and wound up, and then your rights are very limited in what you
Right.
can do. So being quite on top of your agreements and understanding your invoicing, I think that's where a lot of businesses fail, is they don't understand their invoicing. They don't know how long a particular invoice has been due for, and in that regard, also knowing what your invoicing terms say, and where are you able to charge interest if they don't pay within 7 days or 30 days or whatever the terms are. So being quite aware about what your rights are if someone doesn't comply with your agreement or your invoicing terms, and then acting on those rights early on, sending out your letter of demands and engaging in that debt collection process early, because again, the longer you leave it, that person might not be around anymore. And trying to work out, what amount of money are you owed, and because I think the problem that we find, and it's just the way, and it can be unfair, the way the system is, if your invoice is only $1,000, so that's outstanding, the lawyer might charge you more than that to recover it, right? So it's about trying to weigh that up, and what can you do, what processes can you have in place to prevent that from occurring, and can you have the right terms early on? Can you check with the suppliers what their history is in making payments, and the people that you're dealing with, is it likely that, sort of doing that due diligence early on,
Right.
is there other contractors that they work with where they haven't paid, doing those reference checks early? Is there a way that you can secure a deposit before you do all the work, depending on what business you're in?
Completely understand. I think, as you mentioned, if that's $1,000 outstanding, you have to consider the legal cost as well. And I think many small businesses, they leave the money just because of that reason, because they know there's going to be a lot of legal cost associated with it. And
Yes.
but are there any options for those people as well? Like, because it's small amounts with so many people, let's say.
Yes.
What do you think about it?
Yeah, I think you don't want recurring small amounts with lots of people, because
Yeah.
then that something's wrong with your processes,
cool.
and it's best to get legal advice, because in that case it's
Right.
worth getting legal advice, which will help you in the broader range.
Yeah.
But yes, there are community legal centres that will provide you advice at low cost or no cost. There is avenues like legal aid that may, and depending on whether you're eligible to get that assistance, and there are a lot of resources available that are at no cost, so it may be best to engage in that process. VCAT, for example, you talked about earlier, the entire reason why that tribunal was really set up was to try and provide an avenue that doesn't require legal representation. So they're quite helpful, the staff there,
Right.
and maybe engaging in that process.
That's good to know as well. So there are places available that can help you, even if the debt is small and you don't have that amount of money to pay for the legal cost. So that's good to know as well. Now let's talk about the people who come to you. Like, your majority of clients, as you mentioned, come after the mess is made. So let's talk about the people who have already signed the contract, and then they have realized, and they've seen this video, and they're like, let's see a commercial lawyer. Are there any options with them still? Let's say if someone signed just 2 days ago, and they're like, let's still get it reviewed, or they've got a trigger event that lets you.
Yes, I guess it depends on each contract. Is there cooling off period? Is there a due diligence period? Is it subject to finance? Is there avenues that they can get out after they've signed it? So there may be an opportunity to get advice even though they've signed it. There may even be, they're still on good terms. So even though they've signed it, they might go get legal advice and decide that we're going to terminate that contract and sign a new one. So just because you've signed it doesn't mean that's the end all.
Right.
It might still be worth getting advice.
So you mentioned cooling off period. What exactly is that?
So sometimes certain contracts will have cooling off periods. So that means that you can change your mind, sort of like you return clothes that you've changed your mind within the 30 days, kind of like that. They may still have provisions where they can charge a certain percentage. So you can cool off and get out of the contract, but pay a nominal amount, say pay $1,000 or pay $2,000 and you get out. You pay your documentation fee. You pay the other party for having prepared the contract, which is fair. So you've paid out their out-of-pocket cost, but you no longer are bound by this contract and you can leave. So there might be cooling off clauses that allow you to do that. Every contract will say will have those clauses that are specific to that particular transaction.
Right. So normally, do you see such clauses in most of the contracts, or people normally don't put it?
So residential contracts will have them.
Okay.
A lot of commercial contracts will have them. So it just depends on who's drafted it, I guess.
I get it. But mostly, like as per your experience, you see a lot of contracts. Do you see like some things like cooling off period that helps people, who have recently signed things? Like,
Yes.
Is it a kind of a general kind of thing you see, or is
It
it
is
a
a
special
standard.
thing?
Yeah, it is a standard clause, particularly in the residential space or commercial land, or in that kind of space. And it is required by legislation. It is a regulated area, and commercial contracts not necessarily. It's not something that most people will put in a contract.
I understand.
I guess it just depends on what space you're working in.
Cool. Good to know. And what does a damage control look like? Like, if someone, first thing is they did wrong and you found something in the contract. If there is no cooling off period, and is there any damage control for them?
Yeah, so it'll just depend if there are terms that haven't been complied with that might give you a way out.
Yeah.
Is there certain disclosures that they needed to make? So, for example, again, depending on which area, but it's just say you're buying a business that is a franchise, there's a particular, a code that has certain requirements, and maybe those requirements haven't been met. Or if it's a lease and, there's no disclosure statement, or there's other sort of legislative requirements that haven't been met. So there might be a way out. Just because you've signed it doesn't mean you're necessarily stuck with it. That's the lawyer's job to try and find you a way, a loophole or a way out.
Sense, yeah. Completely makes sense. And do you normally charge more fees when normally, I'm not asking about you generally, but lawyers in general, like when a dispute has already, is already there, but like due diligence part, it's still an advice.
Yeah.
So is it like normally when people come after it, the fees is a little more than...
Yeah, I think that the way to think about legal fees is really the amount of time required for that particular work. So generally, if there's a dispute, there's going to be more time required because there'll be more discussions back and forth between lawyers. They'll, by that time, if the dispute has arisen, people aren't necessarily on good terms. So people are quite heated up. Those discussions can be quite prolonged. So thinking about it from that point of view, that the lawyer's likely to spend far more time resolving a dispute than early stages doing the due diligence.
But still, it's not like always, as people have a perception, lawyers' fees is going to be a lot once, we have done something wrong, but it still depends upon a big thing for them can be a small thing for you, and you can just deal with it very quickly, and the fees is going to be according to that, the amount of time spent.
Yes, I think it's really important that early on when you go to a lawyer, you understand the fee structure and you understand the cost agreement that you're provided at the disclosure. Every firm charges differently. There are firms that will charge you by the hour, so it's they do time billing, so it's every 6 minutes or every email, or there's that kind of arrangement.
I've seen that. I've seen some
which
invoices.
Is very common.
It's just people, even if you're making a phone call. I did an internship under a lawyer for like 3 months when I came in Australia, and like he used to charge even for an email sent, even a normal phone call, and I was like, that's good money.
Yeah, it certainly is. So there are a lot of it's quite common practice of we don't do that. We tend to just charge
Right.
by each step. But yes, it is quite common. And I think it's important that you understand that when you're signing up a lot to a
Right, I
lawyer.
think that's good to know because people, especially in our community, they like to talk a lot.
Yes.
They like to ask so many questions, and when they get to know it's going to be chargeable, I think
Yes.
they'll stick to only few questions. And
Yes.
it's good. It's better to know, discuss these things before, so that end of the day you get up like $10,000 bill when you thought it's going to be $1,000, $2,000. So I
Yes.
think that's good to know as well. Now, as part of the damage control, if now this is once the damage is done. Now, as kind of a starting advice that you give to people, like what sort of structure do you normally advise to people? I'm not asking for a specific legal advice here. I'm just asking for a general advice in terms of if someone is starting a new business, what sort of structure they should follow so that they get maximum, they can be saved from any disputes.
Yeah, I guess it depends on each particular transaction and what business they're buying. Are they buying it with people? Are they buying it on their own? What their goals are. Is it they're buying a business to bring up the revenue and then sell it, or are they buying a business that they want to stay in for the long term and they want their family to stay in? So it's really about what their goals are and then trying to decide accordingly. What is more common nowadays is really a company structure where you've got directors and shareholders, and then a lot of people will not sell the company; they will just sell the business when they look to move on. So it's really about trying to work out what works for you in that situation, who's involved. The good thing about a company structure is generally, like you said, there are certain defenses available in that regard in terms of liability, but they don't necessarily extend to every area. So people tend to think just because it's a company, I've got zero liability. That's not the case. Like, for example, if you set up a business under a company structure, and most of your agreements with other contractors or suppliers or clientele were through that company, then yes, the liability is only with the company. But if there's personal guarantees involved, or for example, you're not paying your employees, there can be personal liability there. So just because you've got a company doesn't mean you've got zero liability. You've got duties as directors, as fiduciary duties that you're bound by. So there are quite. It's really important to understand that just because I've got a company doesn't mean I'm invincible and I can do anything. You've still got to follow the right processes and do the right things. Otherwise, there is liability that can come onto you. And it's I think the company structures are great and very common, but it doesn't mean that you're not prone to any personal claims.
Makes sense. And now, in terms of the structures, as we're talking about structures, whose area of advice is it? Is it a commercial lawyer's advice or is it accountants?
Yeah, I think a bit of both. There's a bit of an
both,
overlap generally. So if you're seeking advice about tax implications, in that regard, it's probably best to go to an accountant and you're trying to work out. So I think a lot of the times the accountants and lawyers will talk to one another as well because there is a bit of an overlap. Whereas, if you're just getting advice about this particular person wants to be a shareholder and I want to be a shareholder and what are the shareholder obligations and so forth, then that's really a lawyer's job. So I think it's best to go talk to both and understand where each one sits.
I think that's a very common scenario because even because I work as an accountant,
Yes.
I'm asking these questions so that audience understands it in an easy way,
Yes.
because they normally have that thing in them who to go because they only think accountant is the right person to go, and like we deal with these kind of things on a daily basis, but it's still the legal side of it. Are areas that a lawyer has to take care of. So it's
Yes.
basically I also feel it's a combination of both. So when you're starting a small business or any business, so it's basically you need to be in touch with these two legal professionals as a minimum, so
Yes.
that both of them can do their good job and save you for the bigger disputes in future.
Yes.
And now, as we're talking about small businesses, let's talk a bit about franchises as well.
Yes.
Because that's a very common thing, when people buy a business, let's say even a cafe, or they either buy a brand or they do it themselves. So with franchisees, there's a lot of paperwork that comes because there's so many promises there, and I feel like you might see are all promises true, or like what do you think? What's your point of view on that?
Yeah, I think franchises is a whole different type of business, and there are a lot of obligations generally. What's even more important to understand is the difference between franchising and license agreements that exist. So a lot of people tend to think that they have, they're purchasing a franchise, but it may not be a franchise. It's sort of disguised as a franchise, but it's only a license agreement. So really understanding the differences, and then if you are acting for the franchisor, really understanding your obligations as someone who's giving out a franchise. They're quite extensive. The code is quite comprehensive, and really understanding, are you complying with that, complying with your disclosure requirements and so forth. And generally these agreements are quite lengthy compared to a contract of sale, so it's best to get advice. Most franchisors will require you to get legal advice in any event, so it's important that you understand how that works, and you understand how, if you're the person purchasing, what your relation is with the landlord. Are you having a direct lease with the landlord, or is the franchisor having a lease and you're just a sub-license or a sublease, or is there a license agreement there? So really understanding how that transaction works. So I think a solicitor is best to sort of give you that advice and to walk you through the different steps, and what happens if the business doesn't work but you want to stay in the premises and you want to run an independent business, So working through those scenarios, I think it's important to get that advice early on.
I think that's good information. And what are the major areas where dispute normally arises on, like based on your experience?
I guess it's similar to sort of business purchases. It can be with, which is a unique scenario. A lot of disputes arose around COVID time between franchisors and franchisees because of the way the JobKeeper payments were set up and the way you could claim, because there were certain requirements that the franchisor had to meet and maybe didn't meet, or they were a large company, but the end person who's paying off the landlord, they met those requirements. But so there was a sort of unique setting that doesn't really apply day to day, but it was a unique setting in that regard. But yeah, I think a lot of the disputes will be similar to when you're purchasing a business, but here you just have another entity that you're working with. And it might be that they have certain requirements about refurbishments or certain marketing expenses that you need to work with, and so there's more obligations on you.
All right, good to know. And now let's give audience let's arm them. Let's give them a 5-minute contract scan that you normally do, like major points that you see, and just with an example so that they understand it easy.
Yeah. So in terms of like buying a business, or
in terms of, like, for example, dealing with any contract, there might be some certain things that they should look at. Minimum. Like we have discussed about many of them, but let's say if someone wants to just watch this part of the video and they want to be like, these are the areas whenever you get a contract, what are the areas you have to first look on, and what are the key 5 things that no matter what you can't ignore?
Yeah, I guess looking at broadly in terms of contracts, number one, parties, make sure the right parties are listed. Right. We see that a lot in poorly drafted contracts. So the right names of the entities. If it's a corporate company, we've got the right ACN number, because there can be company names that are very similar. So number one would be getting the parties right, getting your essential terms correct, knowing who's paying what, when those payment terms are due. And again, signing clauses, making sure the right people have signed. So if it's a company, the directors have signed. It's not some random person who has no authority. If it's 2 directors, 2 or more directors, 2 people have signed. So making sure that your contract's going to be enforceable later on. Right. The 4th one would be consideration, like trying to work out. And it doesn't have to be monetary consideration, but most contracts will require consideration. So knowing how the money exchanges, or if there's no money involved in this contract, is it a deed, is it a promise, what's occurring in that regard from a consideration point of view. And number 5 would be, which is sort of the broader term, does it cover the mutual intention of both parties? Is it Is it balanced in that regard, or is it a very unfair contract which is very biased towards one party and likely to be then unenforceable later on? Or is it balanced that it does cover the intentions that both parties are on the same page? You understand what you're signing. You're not just signing clauses because they look great on that piece of paper. You understand the terms that are listed there.
Right. I think that's incredible information, and everyone should at least go onto these areas before they sign anything. And definitely, then you'll still have to take the legal advice that's required. Now we are almost finishing this podcast, and we'll finish it with because lawyers normally have a lot of stories because they deal with a lot of people. So I want to know first the case you'll never forget. One client, one mistake, one lesson. Take your time.
Yeah, I guess the biggest one would be we did a matter a few years ago, pre-COVID, about misleading deceptive conduct in the federal court, and that was a very significant matter. But I think the key point of that case was really, if it's too good to be true, it probably is too good to be true. So that matter was where someone had really invested. It was sort of an investment where there were certain guarantees that were provided. So if you invest X amount of money, there's a minimum guarantee you'll get X amount of return on that money. And it did sound too good to be true initially. And it was a scheme that was set up. I won't go into too much detail. I don't want to give away the particular setup that it continues to occur, unfortunately. But the idea really was that they would, you would just say, to give you sort of broad numbers, you put in 100,000 and every month you would get, say, 7% return on that money. And that's how they would hook in people.
Right.
And you
every
do
month,
it,
7%.
Well,
Okay.
whatever the case. I think it was much higher. I think it was like 30% from memory, but it was much higher. So you're making a good amount of money. I think it was, I can't remember the exact terms now, but it was a good amount of money that you were going to make back. And it sounded great. And so our client had put in that money and he was making, month 1, month 2, month 3, he was getting his return. It was a minimum fixed guarantee. And then later on, at some point, they've decided to restructure and said, you're losing shares in this company. This company is going to be wound up. We're going to do a new company. So I know that you've put in 100,000, put another 50,000 or another 100,000, and we'll increase what money you get back and so forth. So they sort of hook you on.
Right.
They've already built trust because you've been paid the return. Yeah. And then you put in more money, and then and then this sort of rolls over. But by the end, you've put in significant amount of money. And our client had put, from memory, about 600 to 700,000, and then at some point those returns stop. So this case was really trying to about enforce those minimum guarantees. But the difficulty, and the reason why I'll never forget this case, was the setup, or this particular scheme, was so well structured. And when we looked into it and we started running this matter, and there were eight particular people that were involved in the structure. They'd been doing this since the 1990s, so they were very they were so one person, another person, and in various countries as well, not just Australia and New Zealand, and there are other countries involved. And we realized it's quite difficult, even though it felt so unfair for our client. It was a very difficult matter to run in court, very difficult to enforce, and very difficult to get any justice in the sense of justice. And even if you did, we realized that the parties had no money to their name. So, they've lost 600,000, and some of the other parties, they looked like they were quite well off, they're driving really nice cars and dressed really well, all that kind of thing. But on paper, if you did their title searches, there's no property to exist. There's nothing in their name. I guess a sense of justice doesn't necessarily prevail in that case, because you think you've got legal rights, but because of the way that the whole structure's been set up, it's very difficult to get anything. One was very difficult to run the matter in court. It was a very complicated matter because we were dealing with, different areas of law in terms of misleading, deceptive conduct. Very expensive matter to run. We're against parties that are very resourceful, are able to afford lawyers and throw a lot of money at lawyers. And then by the time even if you did get an order in your favor, you're not necessarily going to recover anything. So on paper, they have to pay you back, just say, the 600,000 you'd invested. How do you recover that? There's nothing in their name. So it's really trying to understand the layers of your dispute. And I think the most important lesson to learn is that before you enter into a scheme like that, get advice early.
True.
I think most lawyers would have looked at a scheme like that and said, I don't think this is going to work.
Right. I think it's more from a legal point of view. I think even more than that, it was more than the experience, the experienced lawyers have in dealing such things and finding too good to be true schemes. And they might have faced a similar situation before, and they can tell which is right, which is not. Because the way you're telling those people, they framed it in such a way that a normal people would be like, it's legit.
Yes.
And even as you said, they had a lot of layers. So I'll say even lawyers might mistaken this thing. They'll be like, everything is done in a proper way.
Yes.
And it's just a lot of thinking you have to do when you're putting such big amount of money and getting the right proper legal advice.
Yes, and I think in particular in that case, you weren't putting big amount of money day one. You're starting small, and then
they're giving you that thing so that you build the trust, and then you put in the major money you have. And
so had that person got advice at any other stage before topping up the money,
true.
Maybe you could have mitigated your loss a bit.
He was already getting his share of profit, so he was like, "There's no point."
Yeah, exactly.
And
that's how
they want. That's how the other people wanted it to happen. I think that's all good. Now this is the last question that I ask all the guests on my podcast. Now, what is the biggest decision you have made in your life, and how it has impacted you?
Yeah, I guess I'm someone who really follows my gut, and I think that's always been great. I think the biggest decision I've made in terms of professional life is setting up Regal Lawyers, and I think that's been great. The kind of experience I've had over the last 11 years as a lawyer is quite a variety of work and the type of clients that we work with, and being able to improve access to the legal system. That's something that's quite fulfilling at the end of the day. So I feel quite I think it's been a great career move, and it's worked really well.
Thank you, Mannie, today. So I'll say that was a consultation most people never get to have, and because here's what I noticed today: every story, the cafe, all the stories that were shared in this podcast started the same way. Not a bad person, not a scam, an awkward conversation somebody didn't want to have. So, and every time I asked what the conversation would have cost, nothing. An hour, a few $100s. So have the conversation, ask your cousin, ask your family member before making any big decision. And even though it feels rude, I think go to the lawyer, they'll do the hard part for you. And we'll also provide the 5-minute contract scan that Mannie mentioned in the notes. And I'm Karan Bahri. See you at the next episode. Thank you.